Please rise for the centennial prayer for the courts.
Almighty God, we stand in your holy presence as our supreme judge.
We humbly beseech you to bless and inspire us so that what we think, say, and do will be in accordance with your will. Enlighten our minds, strengthen our spirit, and fill our hearts with fraternal love, wisdom, and understanding, so that we can be effective channels of truth, justice, and peace. In our proceedings today, guide us in the path of righteousness for the fulfillment of your greater glory. Amen.
You may now be seated.
Introduce mo na lang.
Your Honors, good morning. Good morning, everyone. This is a continuation of the public panel interview of candidates for the position of Associate Justices of the Supreme Court, Vice the Honorable Francis Jardeleza and the Honorable Antonio T. Carpio. The panel of interviewers are the following: the Honorable Justice Jose Catral Mendoza, Chairperson of the Judicial and Bar Council Executive Committee and regular member representing the retired members of the Supreme Court. The Honorable Judge Toribio Ilaw Jr., regular member representing the private sector. The Honorable Justice Noel Jimenez Tiham, regular member representing the Academe. And Honorable Judge Franklin de Monteverde Sr., regular member representing the Integrated Bar of the Philippines. Your Honors, the candidates for interview this morning are the following: Justice Manuel M. Barrios, Justice Jhosep Y. Lopez, Justice Pablito A. PEREZ, Justice Elihu A. YBAñEZ,
Tony Richard, please administer the oath.
may I request that you stand and raise your right hand so that I can administer the oath. Do you swear to tell the truth, the whole truth, and nothing but the truth in this public panel interview by the Judicial and Bar Council? So help you God.
The first interviewer will be Judge Franklin de Monteverde. Judge de Monteverde.
Thank you, Justice Mendoza. I will start first with Justice Barrios. You are from Rojas, from Capiz?
Rojas City, Capiz, sir. That's right, sir.
Okay. How many children do you have?
I have 3 children,
And-
2 girls and 1 male.
And they are gainfully employed? All of them?
Yes, sir. They are.
Now, are you healthy? Are you healthy?
I believe so, Your Honor.
Yeah. Thank you, but your medical record shows that you are high in FBS and triglycerides, and also somehow you have a problem with your hypertension or heart as shown by the ECG.
I have maintenance medicines for blood sugar and high blood pressure, Your Honor. But they are controlled.
You are taking medicine now.
I am here.
Okay. You're not a diabetic.
My last reading was about a little over 120. So according to my specialist physician, it's controlled.
I'm asking about irritability and our method of planning and so forth. Have you experienced this kind of situation?
In my case, Your Honor, it has not.
Yeah? Okay, thank you. Now, if appointed the Supreme Court, what do you think will be the biggest adjustment that you will be facing coming, of course, from the Court of Appeals? You have been there for 10 years now?
That's right, sir.
Okay. And what challenges do you foresee if appointed?
Well, I foresee that there will be a little more number of cases that will be handled by myself. As of now, in the Court of Appeals, I have very manageable cases. I have less than 200 or 200. But I foresee that in the Supreme Court, I am aware that the caseload is a little bit high, especially for those entering the court.
Again, will your fasting blood sugar not interfere with your problem, assuming that you will be appointed?
I do not believe so, Your Honor.
Okay. You are now 67 years old, and if appointed as Supreme Court Justice, you will be serving only 3 years.
Yes, sir. Yes, sir.
Such a short stay, but cite to us some ideas and programs that you have in mind that you want to initiate in the Supreme Court.
Well, Your Honor, I would like to condescend a new fight in the Supreme Court. Being a new fight in the Supreme Court, I am not expected, or I would feel very comfortable to initiate moves to change existing policies. But I can certainly share what I can if there should be such moves emanating from the more senior justices.
Now, going over to your SALN, in 2017, it shows that you have a net worth amounting to 19,945,408. Is that correct?
Yes, sir.
A year after, your SALN shows an increase amounting to 27,995,661.12. How do you explain this significant change?
Well, Your Honor, most of my net worth are real properties that I have inherited from my parents. Most of these are in my native town and some here in Manila. In 2016, there was a sharp increase in values of real property in Rojas City. There was, I think, about even a 100% increase in the values. And so that explains the increase of my assets.
Can you remember how much is your total net worth insofar as real estate property is concerned?
In absolute figures, I cannot remember, Your Honor, but I have records to
Yeah, it's here.
consult.
It's here. but you cannot remember, no?
I cannot remember.
Now, during your whole stay in the Court of Appeals, what was the biggest controversy that you were confronted of?
Are you referring to cases?
Cases.
Although I treat each and every case as that I handle as very important, I think it was the writ of kalikasan case that I handled, which I think has the bigger impact. It is because it involved large cities and the water system and the water supply that was affected. It involved several cities in Cavite whose water supply from streams were being brought up to Tagaytay City. And the people of the Cavite towns and cities objected because it definitely reduced the water supply, not only for their own use, but also for the fish ponds and other needs. It also includes, their needs also include the irrigation to their agricultural properties, agricultural area. It's obvious and it's very apparent that there was an error in the appreciation of the good conduct and time allowances given to these people. And so I believe the President has already made issued an order invalidating the release of these convicts. Perhaps it is because of his power of control over the executive branch that he issued this order. He can countermand orders or directives from the executive branch. So, many now believe that these convicts should now go back to prison to serve the remaining portion of their prison terms. I believe that the President is within his power to order the cancellation of these release orders.
Justice Lopez, do you subscribe to the answer of Justice Barrios?
Yes, Your Honor. But if I may cite the People versus Fidel Tan, in that case, they were released because the one who ordered for the release of the convicted person was was the jail warden, when at that time it should be the bureau director. So there was no authority on the part of the warden to issue the release order based on the computation of GCTA. And the court, the Supreme Court then decided that since it has no authority, the lower court, which made the final conviction on the said detainee or prisoner, still maintains the jurisdiction to order the rearrest of the individual since he has not been able yet to complete the prison terms decided on him, Your Honor. But on the other hand, I would like to believe that under the present situation, the President may have the authority not really to order the arrest immediately, but in fact it was not ordered by the President. I think the order of the President was for them to voluntarily surrender to the proper authorities, all PNP and military establishment as well, so that they could register. They could register and ask for a recomputation if they may fall or they may be covered under the GCTA law. If they are not, then the President, through the Secretary of Justice, may countermand the order already issued by the Bureau Director, Your Honor.
What is your take on this, Justice Perez?
Good morning, Your Honor.
Good morning.
May I, without prejudging the issue, Your Honor, because this issue may reach the Court of Appeals even, may I be allowed to give a little context? What they call the GCTA law, Your Honor, is actually an amendment of about 5 provisions of the revised penal code. Article 29, Article 94, 97, 98, and 99. So in that context, Your Honor, this law amended 5 provisions of a code which has more than 360 articles. And I think that's part of the reason why there is this ambiguity about how to implement or interpret this law. And the difficulty is in Article 29 of the revised penal code as amended by this so-called GCTA law. Article 29 refers only to preventive imprisonment or the detention of accused who have not yet been convicted, who are standing trial or awaiting trial. And the so-called exception that this act does not apply to heinous crimes and all that is found in Article 29 as amended by this law. Unfortunately, Your Honor, I think that the ambiguity now arises because you have one article that is amended that may not have considered the entirety of the code. Because as the Supreme Court ruled on the retroactive activity, the revised penal code in Article 22 says since this is of a penal nature and it is beneficial to the accused, then it should be given retroactive application, which is a correct rule. But as I said, because of maybe the lack of foresight in promulgating the law, then we now have these questions of interpretation. Now, to answer directly your question, Your Honor, whether the President may order the rearrest of those who have wrongfully been released, again, we refer to Article 99, which amended again by the same law of the Penal Code, which says that once the allowances are given, they can no longer be revoked. But I assume, Your Honor, that we refer to a situation where the allowances were correctly given. And right now, the information that's coming out, even in the Senate hearings and all that, is that there are very serious questions on the correct implementation of the GCTA law. And there are, in fact, questions about fraudulent awards, wrongful computations, even corruption. And I think in this situation, Your Honor, where the release of the convict is wrongful from the start, then obviously I would agree with Justice Lopez that these convicts should complete the sentence to which they have been, which has been given to them under their conviction.
But does the President have the authority to send him back to jail?
Your Honor, I think the status of these convicts is that they are wrongfully released, and even under the rules on arrest, we can the arrest of people who have evaded the service of sentence can be ordered. I know, Your Honor, that under the Constitution, only a judge may issue a warrant of arrest, and under very strict conditions may a warrant of arrest be issued by a judge. But I think one of the exceptions to this is precisely the enforcement of an arrest when there is an evasion of sentence. because that is an administrative and police matter.
What is your view on this, Justice YBAñez?
Your Honor, please. Good morning.
Good morning.
I agree with the opinions of my colleague. However, if I may add, Your Honor, I believe the President, considering that it has been said that there are irregularities and, in fact, allegations of corruption as it came out in the investigation of the Senate, that the President, under the Constitution, has control and supervisory power over its cabinets and officers and agencies under its authority, Your Honor. So since it's very obvious that there is an irregularity wherein prisoners were supposed not to be included and in fact disqualified from availing of the good conduct time allowance, the President can correct the errors done by its agents or public officials. And since it has the power and authority to control over the actions, and it can disagree with the actions of its duly constituted officials, the President, I believe, by issuing an order for the prisoners who have been wrongfully granted the good time allowance, may, Your Honor, validly order the return of the convicts to serve their sentence, Your Honor, as mandated by the decisions handed upon them, Your Honor.
Okay, thank you. Going back to Justice Barrios. What is your leadership style, Justice? Do you have a good relationship with your staff, with your colleagues, with your peers?
I am proud to say, Your Honor, that I have very good rapport with my office staff and with my fellow justices. I don't have any specific style, but I know it's when I give them due respect, I get respect in return.
Now, if you want to have something done, and these are not performed on time, do you get impatient? Do you get angry?
Not angry, Your Honor, but
Impatient.
A little less than impatient. I have to remind the office staff concerned that this particular specific work needs to be done.
Now, assuming that one of your staff did not obey you, under that circumstance, what would you have done?
Then, Your Honor, I would have issued a written memorandum to remind the staff concerned that she has not followed what was specifically directed of her or him. So at least it's a matter of record.
Okay, was there a time that you feel depressed or remorseful of things that happened in the past?
At this time, Your Honor, I cannot think of any.
But you would agree with me that there were times that you feel depressed,
Oh yes,
not necessarily in the office.
oh yes, Your Honor. I think every person passes through that stage also, or experience that sentiment.
Okay, thank you. Now, insofar as the death penalty is concerned, are you in favor of its revival?
I feel agreeable to the heinous crimes law that was enacted before, and the crimes that's covered by it. Yes, Your Honor. If this is the only way that we can curb the incurrence of these high crimes. Yes, Your Honor.
Can you enumerate the crimes covered by the previous that you mentioned?
Okay. As far as I can recall, Your Honor, it's piracy, mutiny, homicide, murder, parricide, drug offenses, rape, qualified bribery, qualified piracy.
Okay, thank you. How about you, Justice Perez? Are you in favor of its revival?
Your Honor, let me start with what the Constitution says. The Constitution says that only Congress, by law, may impose the death penalty, and only for compelling reasons, and only in the case of heinous crimes.
Assuming that the death penalty has been revived.
Assuming, Your Honor, that Congress has passed such a law reviving the death penalty, then the judicial review of this statute shall involve an examination of whether there are compelling reasons, as the Constitution requires, and whether or not the legislative definition of what is a heinous crime will pass will pass our sense of a common sense of what should actually be penalized by this extreme penalty, Your Honor. But all in all, the imposition or non-imposition of the death penalty is a matter of policy, and it is not for the courts to decide one way or the other whether it is or should not be imposed. And our judicial and the review of such a statute will be limited to what the Constitution requires as to when such a penalty can be imposed.
But you are favorable to its revival?
On a personal level, Your Honor, I think that I am open to considering the imposition of such a penalty in very, very extreme cases. In one particular case, Your Honor, and this is something that I find disconcerting, is that some Filipino citizens are sentenced to death for certain offenses under foreign law. And for a similar crime in the Philippines, these foreigners do not suffer the same penalty. So I would, if I have a chance to sit in the Supreme Court, very, very carefully, Your Honor, consider the principle of reciprocity, which means that if a death is a penalty imposed on our citizens for crimes committed abroad, and those crimes satisfy the constitutional standards of heinousness, then I might consider, Your Honor, agreeing with the law that imposes death penalty in those extremely exceptional cases.
So an eye for an eye, a tooth for a tooth.
I think, Your Honor, it's a question of basic fairness. For the same crime, the same burdens should be imposed.
Your views on this, Justice Lopez?
Whether or not I'm favorable to death penalty, Your Honor. As far as I can remember, Your Honor, the principles that we adopt under the revised penal code, why we impose penalties, is not only for retribution, but also for reformation. If we kill through death penalty the convict, then they will have no chance to reform themselves. So I would like them to reform and go to rehabilitation, but not through a shortcut like the GCTA as it was misapplied, Your Honor. So retribution in the sense they have to stay in prison for a number of years, I think that would be enough retribution, but at the same time, the prison officials must see to it that they will be given opportunities to learn and to reform themselves, so when they come out of prison, they will be a newly reformed person capable of contributing to the society, Your Honor.
But assuming that the death penalty shall have been passed and the elements of the crime would go for a death penalty, will you, if given the chance to be one of the members of the division hearing it,
Yes,
would you be amenable?
yes, Your Honor. My moral conviction should not be a hindrance to the application of the law. And so if there is a law on the imposition of death penalty, so may it be imposed, Your Honor.
Okay, thank you. How about you, Justice YBAñEZ?
Your Honor, since it has been said that death penalty has already been passed and part of the law of the land, my personal opinion on this, Your Honor, is that if a person kills somebody or commits heinous crimes, he forfeits his right to exist. As in the olden times, Your Honor, the death penalty is imposed to exact punishment which society is entitled to. Now, in the imposition of death penalty, Your Honor, there's so much opinion expressed about the protection of the accused. However, none has been mentioned about the concerns, the aggrieved persons, the victims. They stress more on the rights of the accused. That's why there is a strong public opinion, and the President has expressed this, to reimpose that penalty to put fear in the hearts of men. As a deterrent, although I agree also with Justice Lopez and my other colleague that our system of punishment in the penal code is also restorative. But when it comes to heinous crimes, odious commission of crime where a victim is decapitated, I believe that there is a wisdom in imposing that penalty to put fears in the hearts of criminals, Your Honor. And if it is already part of the law of the land, I will not shrink in imposing that penalty. That's my personal opinion, Your Honor.
Now, Senators Gordon and Zubiri last week filed separate bills meant to create a separate facility for heinous crime convicts to isolate them and prevent them from committing more crimes. What are your thoughts on it, Justice Barrios?
Yes, Your Honor. It could be a good idea to place these convicts, those who have been convicted of these kinds of crimes, in a separate area, just like what they have in the U.S., the Alcatraz, so that they will be isolated from society, and based on our recent experience, be not able to continue with their nefarious activities. As we have learned in the recent past, our national penitentiary has not been doing what is ideally expected of them for reformation and correction of the convicts. Instead, they continue with their illegal activities. And it's about high time that we counteract these with novel ideas like a separate detention facility for these kinds of convicts. Thank you.
Your thoughts on this, Justice Perez?
Your Honor, I have no opinion, Your Honor, on whether this will be a wise, effective, or cost-efficient solution, and as a judge, I would not be in a position to answer according to those standards, Your Honor. But I agree with Justice Barrios. I think this has been tried in many other criminal jurisdictions, and it is an administrative matter, Your Honor, that is best left to the executive to decide.
Thank you. Justice YBAñEZ?
This is I believe, a good innovations as far as our to address the conditions in our national penitentiary, to create a separate detention for those guilty of heinous crimes. I believe this is not a new idea. In the United States, there are facilities, detention facilities for special convicts that cannot be mixed up with convicts who have committed minor crimes, Your Honor. And I believe it will prevent the problem that is occurring now in our national penitentiary, where people guilty of heinous crimes can play tennis, can enjoy having an air condition. So I believe this will be a good innovation, Your Honor, for our penal system.
Justice Lopez?
Your Honor, I don't think it would fall under the constitutional prohibition on unusual and severe punishment. So I think there's nothing wrong with it, as long as it can help on the administering the prison terms for these people, Your Honor. No objection, Your Honor.
Justice Lopez?
Yes, Your Honor.
You are now 56 years old.
Yes, Your Honor.
You are still single.
Yes, Your Honor.
Why?
It's not a matter of choice, Your Honor. It's that fact that I was not able to find the right partner as of today, as of now, Your Honor. But who knows, Your Honor? I'm not discounting the fact that I might be able to find one sooner or later, Your Honor.
Now, you were appointed in your current position by former President Aquino in 2012. Is that correct?
Yes, Your Honor.
7 years have passed, and what do you think is your most significant contribution to the Court of Appeals?
Well, for one, Your Honor, in 2017, per records of the Court of Appeals, I came out on top in terms of number of decisions or cases decided. So that means to say that I had the most number of cases decided for that year. And for the following year, I think it was 2018, more or less, I came out on the top 5 in terms of production of cases, Your Honor. And I would not say that these were hastily made, but these were considered as quality decisions, Your Honor.
Now, if appointed as a Supreme Court Justice, you will then be serving for 14 years before reaching the mandatory age of retirement. Cite some novel ideas and programs that you have in mind that you want to initiate in the judiciary, in the Supreme Court.
Well, if not, most of the ideas require constitutional changes, but if it will not have to go through constitutional changes, one idea, but it has already been adopted by the Supreme Court, is the adoption of the video conferencing. I think this will facilitate the hearing of criminal cases, especially involving convicts who are staying from a distance or who have been in prison located outside of the area of the court, especially those which might pose a threat to the national security, requiring them to attend in person to cases to testify in open court might require resources from the government just to be able to ensure that he will not be capable of escaping, Your Honor. Among others, Your Honor.
You joined politics before?
Yes, I was into politics before I got involved in
what?
prosecution service, Your Honor.
Oh, I thought you got involved with somebody.
No, I wish, Your Honor.
Now, what do you think, as a former Sangguniang Panlusud member, what do you think is the biggest role of the judiciary in relation to the Sangguniang?
The biggest role, Your Honor, because as at that time, as member of the Sangguniang Panlunsod ng Siyudad ng Manila, Manila City Council, I was the chairman of the Committee on Laws. So there were times that the ordinances that we passed were questioned before the judiciary, Your Honor, and one of them is the no short time, which was decided by the Supreme Court later on. So at times I had to appear in the judiciary to make sure that these ordinances pass the test of legality and constitutionality, Your Honor.
Okay. Now, as a criminal law lecturer, juvenile offenders who are recidivists, no? Can they validly ask for suspension of sentence?
I think it's one of the exceptions, if I remember it correctly, that the recidivists, they cannot ask for suspension of sentence. But even then, Your Honor, as far as I can recall, that they have to wait until they reach the age of majority before the penalty could be imposed, Your Honor. Sentencing could be done, Your Honor.
So there is an exception.
Yes, I suppose so, Your Honor.
Now, what essentially distinguishes a crime mala prohibita from a crime of mala in se? This is basic.
Mala prohibita, the mala in se, there must be proof of intent, Your Honor, criminal intent. Whereas in mala prohibita, what the law says is prohibited. You don't even have to prove that there was criminal intent on the part of the accused before he could be convicted of such crimes, Your Honor. Yeah.
And who are the public officers?
Public officers under criminal law, Your Honor. All working for the government, I suppose, Your Honor.
Okay, thank you. Now we'll go to Justice Perez. Before your appointment to the Court of Appeals, you were a private practitioner with no background in judiciary.
That's correct, Your Honor.
Okay. Now, how did you prepare for the appointment, your appointment in the Court of Appeals, and what do you think were your greatest, where or are your greatest contributions to it for the past 5 years?
Your Honor, I think that when I applied for and was accepted in the Court of Appeals in 2014, I had by that time more than 30 years of academic experience teaching law, and I've had more than 20 years of practice both in a law firm setting and in corporate setting. So going into the Court of Appeals, I was bringing a broad and diverse experience. And I have found that my long practice of law and my teaching of law for many years were actually indispensable to how I do my work in the appellate court. Now, when I joined the appellate court, Your Honor, I have to admit that there was some growing up period, because coming from the private sector and going to the government sector, these are two completely different worlds where the environment, the work ethic, the culture are not the same. But at the same time, Your Honor, I think that in the Court of Appeals, by applying my long professional and teaching experience, I was able to do my work as an appellate judge in a sense differently from those who have been in the judicial system for for a long, long time. So therefore, Your Honor, when I am faced with a case and I have to decide a case, I approach it not merely as a dispute. I analyze and decide it not merely as a private dispute between two parties, but also an opportunity to clarify or enlighten on what the law is and what the correct application of the law is. And in my decisions, it is my hope, Your Honor, that even if not all the parties will ever agree completely with what I decide, it is my hope that the parties will realize that the law as stated in my decisions is the law as it is and the law as the Supreme Court has interpreted it, and therefore that it will serve as a guide to future conduct. Now, Your Honor, in my experience in the Court of Appeals, I have to admit that there are certain cases which are more, to quote, stressful than others. Big cases are always stressful cases, Your Honor, and as Justice Holmes says, big cases lead to very bad law, and therefore we have to be very careful. And by big cases, I mean cases, Your Honor, where there is so much at stake, whether it is property, whether it is money, whether it is reputation. These cases require utmost attention because of the consequences of any decision that will be rendered. I also find, Your Honor, that there are instances when I am faced with cases that involve very important personal and civic rights, issues that affect an individual more seriously than any other issue, the issues that affect people and society more than it affects mere property or mere material issues. And in these cases, Your Honor, also I find that I tend to spend more time on it because I know that my decisions in this case will not only resolve a dispute, but again, will enlighten the human conduct moving forward.
Confronted with those cases that were, as you said, stressful, how did you cope with those cases?
Well, first, Your Honor, I make sure that my research is good. In other words, I maximize the availability of lawyers who are in my office and make sure that they study very carefully what is involved. Second, I maximize the opportunity to discuss it with them, to throw the idea around, to test the idea with them. I think one of the great temptations of somebody who sits in the chair where I do, Your Honor, is to fall in love with my own thoughts and ideas. I think one must always control the temptation and must learn to listen to what others have to say, because it is in this discourse, in this discussion, Your Honor, that sometimes enlightenment comes. And I do my own work, Your Honor. I read cases, I read law, I read draft decisions, we work on it as long as it takes. So in other words, Your Honor, I think it is this discipline that I have carried over to my work in the appellate court. It is this ability to work with other people and to learn from them as well, and to appreciate the contribution they make to the solution of the problem at hand, which I think enables me to do my work in the Court of Appeals.
Now, your PDS shows that you were already earning at least $350,000 prior to your appointment in the judiciary, in the Court of Appeals. Why did you transfer to the government service? Given that much money that you're earning.
Yes, Your Honor. Maybe for the first 1 or 2 years of my transfer to the Court of Appeals, I kept asking myself the same question. But I think in the end, I take comfort in the correctness of my decision, in the sense that I have reached a point in my personal and professional life where I think there are things which I find more important than accumulating assets, than accumulating money. And I think, Your Honor, in fairness to everybody in this room, we all reach a point like that, where we think that there is no more point to earning more money, that there is no more point of accumulating more things. And at some point in our lives, we do try to do that which we think we enjoy doing. And at certain point, Your Honor, I realized that the skills I have, the experience I have, the visions I have for the last years of my professional life are best spent doing something like this.
With your 5 years experience in the Court of Appeals, what would be your biggest advantage over those who are already in the judiciary applying for the same position?
I think, again, Your Honor, I think as far as I see myself, my advantage would be the broad perspective I can bring to I can bring. Again, I go back to the fact, Your Honor, that I spent more than 20 years litigating in a law firm, 2 law firms actually, and I spent almost 10 years in a corporate setting with a conglomerate that involved 2 publicly listed companies, and which was in all sorts of businesses, from banking to mining to power to land development. And it is this background, Your Honor, that I bring to the court, this diversity, this broadness of experience. And I also think, Your Honor, that my long years of teaching law in my alma mater is a distinct advantage, because it has kept me abreast of legal developments. It has given me a mentoring perspective, in the sense that I approach my work every time as an opportunity to learn things and maybe to teach things. And I think this is my advantage, Your Honor, that I can bring to the court.
Thank you. If appointed in the Supreme Court, what do you think will be the biggest adjustment you will be facing coming from the Court of Appeals for 12 years? And what challenges do you foresee if appointed? Justice YBAñEZ?
Advantages that I can bring to the Supreme Court, if God willing, is my also vast experience, Your Honor. I was a trial judge for 13 years. I spent my 15 years as a trial lawyer in the Office of the Solicitor General, handling government cases and traveling around the Philippines, defending government cases and government officials whose acts have been questioned, and expropriating, Your Honor, vast tracts of land. I was also, I've been more than 10 years now, Your Honor, in the Court of Appeals, and I believe I've acquired competence, probity, and integrity in my work in the judiciary. As a matter of fact, Your Honor, without bragging, when I appointed to the Court of Appeals, the town of Balay, Batangas, where I was a judge for 13 years, the Municipal Council unanimously, Your Honor, passed resolution commending me for dispensing justice with honesty, integrity, and improving the administration of justice in that 4 towns in the province of Batangas. And I, Your Honor, I took up masters in the National Security Administration where the four powers of the state have been taught how to handle cases, I believe helped me a lot with this knowledge about strategy and security matters, Your Honor. Things are necessary to look at things in a broader perspective when a case is presented before me, Your Honor. And with this knowledge and experience as well as honor in the military, since the time was commissioned in 1983, I took active duty, Your Honor, and in fact I served in the Mindanao
You
for
were
50 days.
in the military service before?
I was going always on active duty every weekend, Your Honor, and I joined the military exercise. And with this broad perspective that I had, Your Honor, and in the military and the civilian aspect, and with the study that I had, Your Honor, in the law and in other academics study, and I believe, Your Honor, that my experience that I have acquired and the decisions that I have made, Your Honor, until now I believe that it has already given me enough experience and maturity, Your Honor, to handle difficult questions of law in the Supreme Court, if found lucky, Your Honor.
Now, given the short span of time that you will be in the Supreme Court, assuming that you will be appointed, and considering further that you are now 67 years old, what do you think would be your best contribution?
Your Honor, please, for the past 10 years, 31 judges have been assassinated. And with the experience that I have, I believe, Your Honor, I can contribute by addressing the security problems in the judiciary. I am also chairman of the committee in the Court of Appeals on Security. That I believe that I could devise ways and means to address the threats being experienced now, even until now, by other judges. In fact, when I was a judge, I received that threat, Your Honor, from the liquidation unit of the New People's Army in Batangas because of the many land cases, disputes that are involved there. And I was able to survive, Your Honor, and able even to talk to them and tell them that if they have problems with the cases, because their concerns about the landless people that are claiming lands, and I tell them that they just present their evidence, and then I will act fairly and squarely with them. And I was able to survive, Your Honor. And in fact, they sent me that they have not found any sin or commission of acts against the people in Batangas, Your Honor. That put me in a very relaxing position, Your Honor, because every time I have to look at my back. Now, I would like also, Your Honor, to contribute by addressing the delay in the cases, Your Honor. I believe that we have not exercised in the rules of being strict in modes of discovery. That we should put, before trial will be, parties will come, Your Honor, they should have already completed their evidence. They have already exacted from each other parties admissions and the documents to be presented, so that when the trial comes, there will be no more dispute as to the admissibility of the cases. And if lawyers, Your Honor, who during the interrogatories, admissions made by the other party refuses to accept or make comments, Your Honor, there should be sanction imposed by the court, Your Honor. That's the only time the court should come in. And once trial is started, Your Honor, after the testimony of the witness, immediately there should already be direct or cross-examination, Your Honor. There should be no postponement. So we would advocate limitations of time in resolutions and put strict enforcement on postponements and dilatory tactics by lawyers, which I have observed, Your Honor, even during the time I was a judge. We are very relaxed on this, Your Honor. And I would like also, Your Honor, to, which is now being, I believe, being addressed, is the availing of the technology of getting data, Your Honor, on the detention prisoners who are languishing in jails, and those who are suffering, Your Honor, from sickness, and who should be addressed specially by the Supreme Court so that they'll be given humane treatment, Your Honor.
How do you see the President's independent foreign policy?
The President, Your Honor, since he has all the intelligence and resources at his hand, which we ordinary laymen do not have, Your Honor, I believe is in a better position to decide on how to approach our relationship with international and other countries, Your Honor. And being the chief architect of diplomacy, Your Honor, I would believe that we should give faith to our President, who has shown much honesty and open-mindedness, Your Honor, in addressing the needs of our people, of getting much from other countries' resources that should be able to be availed by our people, Your Honor.
Okay, this will be my last questions. One each for you. Differentiate judicial legislation from judicial restraint. Justice Barrios.
Judicial legislation is the antonym of judicial restraint. Normally, or usually, or as a general rule, courts are shy away from discussions or accepting cases that would invoke judicial power, so that before a case is entertained by a court, four requisites have to be present. First, there must be an actual controversy. Second is that the controversy involves or is presented by a person imbibed with interest. Not any person can just bring out a suit without being actually involved in the controversy and has a personal stake in that controversy. The third requisite is that the constitutionality of the controversy, of the issue at hand, is the very least mota. And fourth, the suit is brought to the court at the earliest opportunity. On the other hand, judicial activism involves the action of a court in filling in a ruling if it finds that the law has somehow left it vacant. In other words, the courts will not shy away because, as we all know, the court will rule on a case only if there is an applicable law for that specific set of facts. I'd like to state an example. In a drugs case, for instance, the law says that the penalty for possession of drugs from Cebu, for instance, from 0 grams up to 1 kilo is from prison correctional to reclusion perpetua. So because this is a special law, courts can impose any penalty within that range. So that in one case, the Supreme Court stated that, all right, prison mayor shall apply to possession of shabu from 0 up to 50 grams. Then, reclusion temporal for possession of from 51 up to 700, and reclusion perpetua for possession of the drug from 751 grams up to 1 kilo. So, the Supreme Court in this case put into the law what is not found in the law. Thank you, Your Honor.
Justice Perez, what is the doctrine of processual presumption?
To the best of my recollection, Your Honor, it's a doctrine. It is a doctrine in private international law that presumes that the law in a particular jurisdiction is the same as the law in another jurisdiction, unless there is contrary proof.
In international law, what is the doctrine of unilateral binding declaration of heads of state, and how is it is applied? Justice Lopez?
Well, Your Honor, as I understand it, unilateral binding declaration, when a head of state declares something to the whole world, it should bind that country and that state, Your Honor. So that means to say there must be a clear intention on the part of the head of state and or the head of government to bind himself in agreement with the when it comes to its relation with other countries in the United Nations, Your Honor.
Justice YBAñEZ, rights beget responsibilities and progress begets change. How do you understand this?
Rights begets progress, Your Honor.
Rights beget responsibilities and progress begets change.
Well, my understanding, Your Honor, is rights begets responsibility. It's because it is necessarily follows, Your Honor, that if you have rights, you have responsibilities with the rights given to you to make that right, apply that right proper, practice the right things that is given to you, what is due to you. And with that, Your Honor, you have responsibility to preserve and say to it, Your Honor, that the rights given to you will not be taken away from you because you do not deserve it. Now, when it's about the progress, Your Honor, I believe that it also shows that once the responsibility is given to Your Honor, progress will come if you will make sure that you're doing what is right and what is best in the prevailing situation that you are in, Your Honor, so that you will be more effective as a person, as a leader, Your Honor, and in the society.
Okay, that will be all. Good day and good luck to all of you.
Thank you very much, Judge De Monteverde. Justice Tigan.
Thank you, Mr. Chairman. Good morning, Your Honors. You're all my friends and former colleague in the Court of Appeals, where I served for 14 years before I was elevated to the Supreme Court. Let me ask you an easy question. Do you think the Supreme Court is always right? Justice YBAñEZ?
I believe, Your Honor, the Supreme Court is always right in their own from their own perspective, Your Honor, from their own position.
From your perspective, as a potential member of the court, do you think the Supreme Court is always right?
I believe, Your Honor, that there's nothing in this world that is always perfect. And the Supreme Court, I believe...
And if you finally join the court, would you be willing, ready, and able to revisit the pronouncements of the court, and if possible, reverse them?
Your Honor, I believe that if elevated the Supreme Court with God's permission, there is a wisdom, Your Honor, in revisiting decisions, jurisprudence, which is very obviously wrong, and that remedial measures should be made, Your Honor. And a justice should, true to his word, Your Honor, should be able to do that and be honest and humble to make the necessary corrections if needed, Your Honor.
Justice Barrios, what would be your attitude towards the members of the court when you finally join them? Will you be differential to the senior members of the court? Will you be swayed easily, influenced by them? And will you be sticking as much as possible to existing jurisprudence and not change them at all?
First of all, Your Honor, as a member of the Court of Appeals, we follow the rule of stare decisis. So irrespective of our personal views on a certain facts, we have to follow the Supreme Court. Now,
the question is, when you are already a member of the court, you will still be obedient to what the court or the majority or some members of the court will be espousing?
I will go to that, Your Honor, so that whenever, God willing, I am appointed to the Supreme Court, my view on this will be different. I will consider myself a co-equal in terms of ruling on a case before the court. I will not be swayed by the majority vote. I will, in fact, present my views
Will you think,
on a certain issue.
will you think independently?
Precisely, Your Honor. I will have my own thoughts on a specific issue. I will speak out my thoughts on the way I should rule on a certain set of facts. Be
But
that in
you
favor
have
of...
been a justice of the Court of Appeals, and the training has always been to decide cases in adherence to existing jurisprudence. And now you are in the Supreme Court. Will you consider all existing jurisprudence as sacrosanct, like the Bible? They cannot be changed, they cannot be revisited at all.
I will have a different view on that, Your Honor. I will have, I said, an open mind on every set of issues that comes before the court.
An open mind, you are suggesting that you will listen to others, that you are willing to be influenced or swayed by others, when you said you have an open mind?
Not necessarily, Your Honor. When I said open mind, I mean that I can speak my own mind and not necessarily adhere to what the others say. In fact, I am open to revisiting certain rulings of the court, which I may find no longer adaptable to the present times.
Justice PEREZ. Good morning.
Good morning, Your Honor.
Is it appropriate for a member of the Supreme Court to go to public fora to ventilate views on matters of public interest, just like what Senior Associate Justice Antonio Carpio does occasionally, and go to social media to express certain thoughts, just like Justice Marvic Leonen does on certain occasion. Is it appropriate?
Your Honor, as far as I am concerned, justice, particularly one of the Supreme Court, is better read than heard. And that I think that that one should avoid social entanglements or public appearances where opinions are sought not in the context of decision. Now, in the case of Justice Carpio, Your Honor, I respect his views on the matter. I think he's doing an important public service. And when he makes speeches about the West Philippine Sea, he is doing it in the context of legal education. Now, in the case of Justice Marvic, on his commentaries on love and affection, Your Honor, I respect. But will I do the same thing? I will not, Your Honor.
Justice Lopez, do you recall the meaning of the condonation doctrine?
Yes, Your Honor.
What is it?
The condonation doctrine, any misconduct on the part of any public official who has been re-elected will be sort of condoned and will not affect his tenure after his re-election, Your Honor.
It condones,
It condones
which liability?
Administrative liability committed during the earlier term, Your Honor.
What is the statutory or constitutional basis of the condonation doctrine?
The public official is elected for a term, and he served for the term. So any misconduct committed during that term will only relate to the term for which he was re-elected.
You're not answering the question. What is the statutory basis or constitutional basis of the condonation doctrine? Is there a statutory basis or constitutional
None that
basis?
I think of, what it was because of jurisprudence, Your Honor, that the court has decided that one who has been re-elected is sort of condoned by the electorate in re-electing him for the same position, Your Honor.
If you claim that there is a statutory and constitutional basis for the condonation doctrine, why was it abandoned by the Supreme Court?
No, I think there is no statutory or constitutional basis. What I said, Your Honor, is that there was a jurisprudence which justifies the condonation doctrine.
So this is an example of the Supreme Court changing its mind.
Yeah, this was the case of Binay, Your Honor, when he was the young Binay, Binay Jr. was re-elected into the same position. The Supreme Court said that the condonation doctrine may not continue anymore after that case, Your Honor. So in effect,
so there's a cut-off period.
yes, Your Honor.
Will cases filed, still pending, before the Supreme Court prior to the pronouncement on Binay abandoning the condonation doctrine, but not yet decided, still covered by the condonation doctrine?
There is no decision yet by the Supreme Court on that matter, as far as I know, Your Honor. But as we do it at the Court of Appeals level, Your Honor, as far as I can know, only actions done or condonation or re-election happened, or the misconduct was committed and the re-election happened before the decision of the Supreme Court on the Binay case, Your Honor.
I
But not after, Your Honor.
I circulated a decision with the court, but it was not acted upon because I retired from the court. All right. Let's talk about the good conduct time allowance. Justice Barrios, is this law constitutional? Do you see anything unconstitutional about it?
Sir, are you referring to the new law, the amendatory law? I do not find anything unconstitutional in this new law, the amendatory law. In fact, good conduct has been in the revised penal code ever since 1932, when the revised penal code took effect.
The fact that there was vagueness in the implementation, the fact that there is confusion as to its interpretation, will, in your mind, does it reflect on the merits of its constitutionality?
I do not believe so, Your Honor. If there is an ambiguity that can be explained or by the internal rules or implementing rules and regulations.
So you're saying the implementing rules and regulation can supplement a lacuna or a deficiency in the law?
Within the meaning and intent of the law.
Will that not usurp legislative function, since it's the legislature which crafts the law?
In the law, the function of crafting the implementing rules and regulations was, I think, given to the DALG and the DOJ. And it is within their power, with their authority, to craft the rules and regulations to implement the spirit and intent of this new law. For so long as they do not go beyond these provisions and intent, legislative intent, it will be valid, Your Honor.
Justice Ibanez, since it is the court which orders, which convicts a prisoner who is guilty of a crime and orders his detention, is it not logical that it should also be the court that should order the release of convicted prisoners if after computation of the good conduct time allowance has been correctly made?
Yes, Your Honor, based on the premise you have stated, since it is the court that convicted. However, there is a law that provides regarding the conduct allowance, authorizing the Director General of the National Believed Prison.
Tell me something fundamental. If a law has been in existence for 50 years, it can never be declared unconstitutional. Is that what you're saying?
No, Your Honor. If there is a defect, Your Honor, in the law, I believe that it can be, especially if it is unconstitutional.
There is a presumption of constitutionality.
Yes, Your Honor.
So far as a law is concerned.
Yes, Your Honor.
But even if a law has been in existence for a century, it can still be assailed as unconstitutional.
Yes, Your Honor. When there are changing times, Your Honor, in the situation calls for a different interpretation because of the changing times wherein the law should also, Your Honor, be alive and effective, Your Honor. The law could be declared unconstitutional, Your Honor.
And going back to the good conduct time allowance, can you tell us if there are some provisions there which might be of doubtful constitutionality?
From what I gathered, Your Honor, from the newspaper and the discussions about the issue, what I found, Your Honor, I believe, is when the confusion that caused here, Your Honor, in the implementation was when the implementing rules was passed. It was stated that the giving of time, good conduct time allowance will be given prospective application, and the Supreme Court made a ruling that it should be given a retroactive effect because it diminishes or reduces the sentence or penalties that the convict or accused should be entitled.
Now, you mentioned newspaper accounts. As a justice of the Supreme Court in deciding cases, will you take judicial notice of newspaper accounts, the public views on social media, or the official pronouncements of government through media?
Your Honor, I should not, Your Honor, because it should be the decision, official publications of the Supreme Court should be the one that should be followed. And
be based on the records,
yes,
the
Your Honor,
evidence
based on the record, Your Honor,
presented, the arguments that may be made during oral arguments.
yes, Your Honor, it should be the official pronouncement and records appearing from the Supreme Court, Your Honor.
Justice Perez,
Your Honor.
the only issue raised in the case of the good conduct time allowance, in the case of the inmates versus the former SOJ de Lima, was the constitutionality of the implementing rules and regulations. Ostensibly, the implementing rules and regulations made the application prospective, and the Supreme Court struck down that for being unconstitutional and gave it retroactive effect. Can you tell me whether the IRR is strictly in the nature of a penal law?
Your Honor, the implementing rules is
Administrative.
administrative. It implements what the law says. And if I may say so, Your Honor, I think the difficulty, an important constitutional problem with the law as it is now is this. The Article 29 of the Penal Code as amended refers to preventive imprisonment. And some have taken the position that the exemption of heinous criminals, crimes and all that applies only to preventive imprisonment, but not to those who have already been convicted by final judgment. I think that position, Your Honor, will result in a very serious question on equal protection. Because why would good conduct benefit be available only to preventive detention prisoners, but not to those who have been already convicted by final judgment?
Under the IIR, it was being implemented
For all, Your Honor.
for all.
That's correct, Your Honor.
Now, assuming that the good conduct allowance applies to all, that in effect will that not in effect amend existing provisions of the revised penal code on penalties for specific offenses? And since it is a good conduct allowance, it does not specify to which crimes it is applicable. Can that also raise some constitutional concerns?
I think, Your Honor, it will raise a need for judicial interpretation precisely of those issues. For example, on penalties, Your Honor, we have rules like the threefold rule. And we have, in the case of reclusion perpetua, a maximum imprisonment of 40 years. So we have many, as I said, Your Honor, I think what happened was when Congress passed the GCTA law and they amended 5 provisions of the revised penal code, what they failed to consider is the effect of these amended provisions on the entire code. And that is the reason, Your Honor, why I think we will have these judicial issues that ultimately will have to go to the Supreme Court for proper interpretation or even for striking down.
Justice Lopez, the matter of the good conduct time allowance was brought to the Supreme Court with respect to the constitutionality of the implementing rules and regulations. Had the Supreme Court found other provisions of the law unconstitutional, should it have been proper for the court to discuss those provisions and strike them unconstitutional as well, even if they were not raised in the pleadings by the parties?
Well, the rule is, Your Honor, the provisions must be considered or presumed to be constitutional unless and until the Supreme Court says so that it is unconstitutional.
Precisely,
So since
but
it was-
what should be the
yes.
approach? If you are in the court and you are the ponente, and
Since,
a law is being assailed as unconstitutional, a particular provision of the law, like item number 5, but in your reading of the law, you see other items in the law to be similarly unconstitutional, should you proceed during the deliberation to declare those other provisions unconstitutional as well, even if it was not raised by the parties?
Your Honor, because the rule is unless it is necessary to declare so.
So
The Supreme Court-
the court has just
Unless,
to keep
Your
quiet.
Honor,
Just to keep quiet.
unless the Supreme Court may deem it of transcendental importance, Your Honor.
To be prepared and think
Yeah.
like you are already in the
Yes.
Supreme Court. So you're not distancing yourself from
Yes.
the Supreme Court. So putting yourself in the shoes of a justice of the Supreme Court, how would you approach it during the deliberation? Will you bring it to the attention of the other members of the court that similarly other provisions
If
are
I,
unconstitutional and should be struck down?
if I were in the Supreme Court, Your Honor, I would consider it as transcendental importance to avoid repetitive, because there is this principle that a case may be repeatedly filed again, time and again with the Supreme Court. It might be well for the Supreme Court to decide the constitutionality issue at that point in time instead of disregarding the issue at all, Your Honor.
Can the court grant relief which is not asked for?
In some cases, declaratory relief might be, it could be the cause of a case in the future, Your Honor, and the Supreme Court, by virtue of the declaratory relief, may decide on the matter, Your Honor, even if there is yet no actual controversy on it being raised at that point in time.
All right, my last question for everybody. There is a House Bill 3957 filed by Ako Bicol Party List Congressman Garvin and Elizalde Co, penalizing the crime of stealthing. Justice Barrios, you seem to be frowning. Do you have an idea what the crime of stealthing is? STEALTHING. Just make a guess if you have the crime of stealthing.
I reacted, Your Honor, because I have no idea about stealthing.
Anybody? What is stealthing? Stealthing refers to the act of covertly removing a condom during sexual intercourse when the sex partner has only consented to condom-protected speech. And it will be classified under that proposed legislation as sexual assault or rape by modifying Republic Act, the provision of the RPC, and Republic Act 8353 or the Anti-Rape Law of 1997. Justice Barrios, is that constitutional? Stealth thing. So when you go home, you tell your wife that is a crime, okay? Do you understand the meaning of stealthing?
It will be
There was a
considered rape.
case. There was a case abroad. There was consented sex with a sex worker, but the sex worker, although it was agreed to be consented, filed a case against the customer because they agreed to protected sex, and yet the customer removed the condom before sexual intercourse. Is that constitutional?
As a matter of legislation, in the matter of legislation, Your Honor, that would be up to our legislators.
Will you consider
I can-
that sexual assault or rape?
But definitely, I would not consider that sexual assault or rape in the context of Republic Act 8353.
But the sex partner consented to protected sex, and the guy removed the condom. So was there consent when there was it was covertly removed?
Not in the context of rape or sexual assault as defined in
But we
Republic
have
Act 8353.
jurisprudence to the effect that rape can be committed against a spouse, for example, if the spouse did not consent to it. If you force upon yourself on your spouse, that can be rape, correct?
Precisely, Your Honor. It was consented sex, but the removal could be another offense, Your Honor, but definitely not in the context of rape or sexual assault. That is my view, Your Honor.
Justice Lopez, what is the neutral desk law signed by the President?
Well, the neutral desk law, as far as I can remember, Your Honor, it would be unfair to those who have been writing using their left hand. So instead of favoring only those students who use the right hand, the President deems it wise that there must be a neutral desk where both the right-handed people and the left-handed people will be equally situated, Your Honor, that they can make use of the desk without affecting their physical health, Your Honor.
Justice Perez, what is the community service law, and who is the author of that law?
I'm sorry, Your Honor. I
It
have
has something to
no
do
knowledge.
with criminal offenses.
Yes, thank you, Your Honor. I don't remember the author of the law, but I thought this law which allows the imposition as penalty instead in lieu of imprisonment, that a person accused and convicted of a light offense may be sentenced to community service over supervised community service instead of imprisonment, Your Honor.
I will ask you for the last time, who is the author of that law? Otherwise, we will not vote for you.
I'm really sorry. I am not aware.
Senator Gordon is the author of that law. Justice YBAñEZ, who is a transgender? If you cannot define,
Transgender, Your Honor.
can you describe the transgender?
Male person, Your Honor, or a person who believes and feels that she is a woman, Your Honor.
What do you call the father or the mother of a transgender?
I don't think there is a change on that, Your Honor. The father is still a father and the mother is still a mother.
Transparent.
Transparent, Your Honor. This is really...
Is gender and sex the same? Aside from the spelling, is gender and sex the same?
Personally, Your Honor, I don't find
I'm not talking of your personal experience, but
Yes, Your Honor.
as a jurist, as a magistrate, is gender and sex the same?
I believe, Your Honor, that it is, to me, personally, as far as I know, Your Honor,
Which is a matter of choice.
the gender, Your Honor, is a matter of choice. But the sex really is, it is from birth, Your Honor, sex is determined from birth, wherein the midwife or the physician
When the parents,
examines.
if a pregnant woman undergoes ultrasound and the prospective parents would like to know the sex or gender of the child, the doctor can say, let us wait until he reaches adulthood and chooses which toilet to use. Is that, should that be the answer?
That is really very complicated, Your Honor. That really poses a problem. But
Transgenders are ultimately allowed to use the comfort room designated for women, if ultimately allowed. Will there be a violation of privacy rights of women?
we've not yet found any decision about that, Your Honor, but I believe...
Just your personal thoughts.
Yes, my personal thought, Your Honor. It will be a violation, Your Honor, because as far as women is concerned, a transgender who believes she is a woman is still from their own perspective, he is still a man, Your Honor, and it will really violate their privacy.
If the SOGIE bill is passed into law, what is SOGIE, Justice?
It is this sexually, sex orientation, Your Honor, gender identity.
Expression. If it passes into law and transgender are allowed to make use of comfort rooms of their choice because they identify themselves as women, for example, does it mean that transgenders can enter exclusive girls' schools as well?
That is another question, Your Honor,
So
because it will involve academic
transgenders-
freedom, Your Honor, that is school.
Transgenders can go to St. Paul, Assumption, St. Scholastica, and other schools for women?
Yes, Your Honor. It will involve the policy of the school, Your Honor, on their academic freedom, wherein the school can decide who are people to be admitted or students to be admitted. And I believe there is a constitutional decision which respect academic freedom of the school.
Purpose of those questions is to impress upon you that if you want to join the Supreme Court, you should have an active mind, okay? You should not be constricted by jurisprudence because in the first place, you are joining a court that will make jurisprudence. All right. So thank you and good luck.
Thank you, Your Honor.
Thank you very much, Justice Tiam. Judge Ilaw.
All right, thank you, Mr. Chair. But the only question I have to ask the gentleman, do you need a break? You've been sitting there for 2 hours. Who wants to be relieved? To relieve. Can we have a break of 5 minutes? 5 minutes, please.
Okay, we will now resume with the interview. It will still be Judge Ilaw.
All right, thank you. Mr. Chair, yes, I just have to trust a few questions. Gentlemen, you had been interviewed extensively by this panel. All right, can we start with Justice Barrios, not necessarily the order of age? How young are you now, Justice?
I'm going 67.
67. All right, who do you look up to in the Supreme Court, past and present, and why?
Your Honor, no one in particular, but I look up to the court as a...
Yes,
But
past
no,
and present, in the way of their attitude, demeanor, writing skills.
I have close association with Justice Josep Belusilio. He's a townmate, and I have known him personally, and in his which in the Supreme Court. His demeanor is the people who his demeanor is reputable. His demeanor is good. The way he acts, the way he treats people, the way he deals with the public. I would like to emulate on the way he does those things, Your Honor.
All right, let's do it in a reverse way. Justice Lopez, who do you look down to in the Supreme Court, past and present? The worst?
None that I can think of, Your Honor. They have been there, so I think they have all the qualifications and, of course, the competence why they were selected to be part of the Supreme Court in the first place, Your Honor.
And who do you look up to?
Look
or
up
a role
to, Your Honor,
model as past and present?
Justice J.B. Reyes, the one who wrote People versus Fidel Tan in 1959 case, still applicable to this day. And I had the chance of encounter with him when he was already retired at the College of Law. And another one could be Dean Cortez, who was my professor in constitutional law. At present, Your Honor, I may consider, of course, C.J. Bersamin and of course the two members of the JBC who came from the, because they have shown the temperament and demeanor of a good justice, Your Honor.
Good answer.
Yes, I'm still young, Justice Lopez, 56 years old. And you have notable changes in your application requirements that since your last interview?
Not really, although I continue to teach law in 3 different schools, in UP, New Era, and at Pamantasan, and also in on 3 different subjects, Your Honor. But if I may also relay to the council, because I was not able to include it in my application. I had undergone a surgery about 45 days ago, Your Honor. This was to remove my prostate, Your Honor. But it was done. There was no incision. It was only done through laparoscopy. So it took me only about 2 weeks, and I was able to come back and start running and playing golf. So I'm perfectly healthy as far as I'm concerned, Your Honor.
And what do you think is or are the cause of enlargement of prostate?
Because of age, probably I'm beginning to age already at the age of 56. But
non-use,
yeah.
overuse, or improper
It
use?
could be both, Your Honor. I'm not aware.
Yes, overuse, or improper use. So,
I invoke my right to remain silent, Your Honor.
so still single. Ano?
Yes, Your Honor.
How is single blessedness?
Well, I think, as my pastors used to say, it's a gift from God, because probably I have more time to do my work and to do some social work at the same time, Your Honor. But of course, as I mentioned earlier, I still have intention of getting married sooner or later, Your Honor. If I may be able to find one.
All right, Justice Perez, you still teaches law subjects in law schools?
Yes, sir.
Well, drawing back, what did you learn in school that has proven to be the least useful?
Sorry, Your Honor. In terms of subjects, I think, and this is relevant because of the ongoing review of the legal curriculum, there are certain subjects which have been overrun by time. Negotiable instruments law, for example, Your Honor, is by consensus already a subject that may be not as important as it was before. In terms of other subjects, Your Honor, I think I did not find quite useful will be the practice subjects, practice court and all that. The reason for that is the actual living real practice in real courts is very different from controlled classroom practice. So, and one thing we have learned is that there are many things they do not teach in law school that can only be learned in actual work.
There are no longer introduction to law subjects, even Roman laws?
Yes, Your Honor. They have, as far as I know, they have removed introduction to law, Roman law. They have removed legal accounting. They have also removed legal philosophy because I think the present legal curriculum does not give stress on what they call perspective subjects because of they need more and more time to concentrate on substantive subjects.
And how could you use your position you're applying for to help law students learn only the useful subjects?
I think, Your Honor, even sitting in the Supreme Court, I think it is not only that we are allowed, but that we are encouraged to continue to be participative in the development of law. And therefore, I would think that once if ever I get to the Supreme Court, Your Honor, then I will take every opportunity to lecture on points of law in order to teach students the more difficult points of law that cannot ordinarily be learned in a classroom setting. For example, I am aware, Your Honor, that in the U.S., for example, justices of higher courts, whether federal or even the Supreme Court, are invited from time to time in a legal symposium or to give a lecture on a particular field of law to educate the bench and the bar. In fact, Your Honor, I'm aware that, for example, the lectures of Justice Cardoso, the lectures of Justice Holmes, have become classic books in legal knowledge, and these were delivered while they were sitting in the court, and they were turned into publications later. And I think it is an important function of justices, Your Honor, to continue to educate, not necessarily by teaching, but by continuous engagement with law students and law professionals.
All right, thank you. Yes, Justice YBAñez, how are you? How about your health again?
I'm fine, Your Honor. Thank
There's
you.
any problem with your health?
I see no problem with my health, Your Honor. I could still do push-ups. Could do 20 to 30, even 40, as long as I'm not, I've not suffered from sleepless nights, Your Honor.
Don't you have HIV? Hair is vanishing.
It is not a problem, Your Honor. I'm already a senior citizen. I don't need to attract women, Your Honor.
All right, if you could invent something, what would it be and why?
To invent, Your Honor.
If you could invent something,
Since, Your Honor, you mentioned about hair, I would invent, Your Honor, that I could invent a medicine that could make my hair grow, Your Honor.
all right, thank you. Now, here's one, a Twitter question. No one of us ventured to ask. All right, Justice Barrios, you've been with the judiciary for how many years?
From the time I was appointed as MTCC judge up to now, about 27 years, 5, 7. Yes, I think about 27 to 28 years.
All right, here's the Twitter question. Chief Justice Bersamin is about to retire on October 19, 2019. Among the 4 applicants vying for the Chief Justice post are Honorable Diosdado Peralta, Honorable Stella Perlas Bernabe, Honorable Andres Reyes Jr., and Honorable Jose Reyes Jr. Who do you think is the most deserving of the position?
I believe any one of them are well qualified to the Chief Justice post.
Question is the most deserving of the position. It will not be taken against you. Remember that Justice Barrios.
That is a very difficult question, Your Honor. They have all been to the Supreme Court, and I said anyone would fit to that post, Your Honor.
Justice Lopez.
My impression will not be important, Your Honor. In the end, it will be JBC and the President who will decide on it. But even then, Your Honor, I think all of them are qualified and all of them may be considered as most qualified, Your Honor.
Yes, Justice Perez.
Yes, Your Honor. I also likewise would leave it to the best judgment of the appointing authority, Your Honor.
Same, Justice YBAñez.
I believe, Your Honor, I will not be competent to make an opinion about that, since I believe also they are all qualified, having been in the Supreme Court for many years.
That going back to the issue or the matter of the judicial stability, as by Justice Tiham, if you're aware, in the Supreme Court, the open-mindedness, just like Justices Carpio and Leonen, who like press conferences and media. Justice Barrios, is this not improper, following the canons of judicial conduct? In the case of Justice Badoy Jr., 443, Philippine 296, 313, which ruled that magistrates are not actors or politicians who thrive by publicity. Publicity undermines the dignity and impartiality of the magistrate. Do you still go along with the idea, the impression that there's nothing wrong with magistrates using the media and press conferences?
Your Honor, I still believe that judges or justices should be their works, their opinions should be read rather than heard. If it is necessary to publicize works of judges or justices, that could be done through, not personally, but through the court spokesman, since there is one in the Supreme Court. I still maintain that the decorum of judges should not be to announce their decisions, defend the same publicly, because that will demean the exalted position that they have. In other words, I go with the ruling in Bado, Your Honor.
All right, Justice Lopez, you had been a politician before, and I understand that you have been a councilor in the old district of Manila
Yes,
for
yes.
so many years. You had been the city prosecutor of Manila likewise.
Yes, Your Honor.
You are a good friend of then Mayor Atienza.
Yes, Your Honor. He was my mayor at that time. I was councilor, Your Honor.
And you belong to several organizations.
Yes, Your Honor.
Do you think that members of several organizations is a curse or a blessing? How about the conduct of being free from any impropriety, as well as improper connections or intervention or interference?
But those were the days, Your Honor, that I was still involved in politics. But right after retiring from politics, and I went into this prosecution service and into the appellate court, I have never involved myself in any organization anymore, except membership, Your Honor. But I hardly attend any meetings anymore, just to make sure I will remain impartial in all my decisions, Your Honor.
All right, Justice Perez, how are decisions reached in the Supreme Court?
Well, first, Your Honor, the Constitution says that decisions can be made by the Supreme Court in divisions of 3, 5, or 7, or en banc. The process of decision-making, as far as I know, Your Honor, is that deliberations is an important aspect of the work, and in the sense that the justices, whether they sit in bank or they sit in divisions, actually do take time to discuss cases together, to exchange views, to convince one another of their positions until a position is reached and will be announced in an appropriate ruling. Now, I'm also aware, Your Honor, that under the Constitution, doctrine and division rulings are rulings of the Supreme Court, because we have under the Constitution only one Supreme Court. But I'm also aware, Your Honor, that the doctrinal ruling of a division cannot be overturned by another division, but only by the en banc.
All right, Justice YBAñEZ, can you cite the specific provision with respect to that question, Article 8, Section 13 of the Constitution? How are decisions reached in the Supreme Court?
The Supreme Court, Your Honor, it's a collegial body, and decisions is arrived out by deliberations collegially by the members of the Supreme Court. It is done, Your Honor, by by meetings personally with the members, and they discuss and exchange opinions on how the case should be decided, Your Honor. And once it is arrived at it, somebody is assigned to write the ponencia. And if there is a dissent, Your Honor, the dissenting justice may do so, either in an extended dissenting opinion or just a mere short statement that he is dissenting, Your Honor, whether he agrees to dissent totally or partially.
All right, Justice Barrios, what can you say more specifically for such provision?
Yes,
You are applying all to the position of Associate Justice Supreme Court. You might as well, and we presume that you know how are decisions reached in the Supreme Court.
Okay. Yes, Your Honor. From that provision of the Constitution, we learned that cases are handled by the Supreme Court as en banc or in divisions. There are certain cases that belong automatically to the Supreme Court, like issues of constitutionality, issues of that, issues where a lawyer is being punished, issues where that have been referred to by the division, and also all the rest belong to the divisions. In the divisions, as of now, there are 5 members each. So there are 3 divisions. The first division is chaired by the Chief Justice. The second division is chaired by the second most senior rather. And the third division is chaired by the third most senior. The matters, or rather, the division holds sessions or deliberations during Tuesdays, and the divisions hold their deliberations on Mondays and Wednesdays. Additionally, normally a division decides a case if 3 of them concurs. If not, it is referred to the en banc.
All right, Justice Lopez, do you agree that lawyers as well as magistrates should be abreast with recent legal developments? How do you do this?
Yeah, most certainly, Your Honor.
Are you aware of this People versus Romilim, penned
Yes,
by
yes, Your
Justice Peralta?
Yes, Your Honor.
What's the ruling of the court
The ruling of the court,
in reversing the acquittal of the grant?
Section 29 of the implementing rules, of the law itself, must be applied strictly with regard to the chain of custody rule, Your Honor. So in that case, Your Honor, it was decided that the witnesses, as of now, there are still 3 witnesses in the three witnesses. One is the barangay official. The 2 others are member of the media, or any member of the DOJ. Right now, it's 2 of the 3, but the presence of the barangay official is required, and the presence of 1 of the 2 others, Your Honor. Among others, so it must be strictly applied as decided in the People versus Lim case, Your Honor.
Justice Perez, could you synthesize the standing rules on compliance with Section 21(1) of the Dangerous Drugs Act? Every case of People versus Bisferas, penned by retired Justice Del Castillo.
The amendment to Section 21, Your Honor, on the chain of custody rule, my best answer, Your Honor, is that as Justice Lopez said, there is now under the amendment a requirement of at least 2 witnesses. There is also the rule on the taking of inventory and photographs, while the rule is not strictly that it should be in the place of the happening or commission of the crime. The rules also require now, Your Honor, that if there is deviation from any of these strict rules, the public officers or the policemen are required to execute statements under oath to describe the events leading to the deviation and the justification why the strict rules on chain of custody were not followed.
Justice YBAñez, how does the Supreme Court define the requirement of physical inventory and photograph of the illegal drugs immediately after the seizure and confiscation?
Yes, Your Honor. The decision of the Supreme Court requires that immediately after the seizure, the police officer should mark exhibits, put markings in the presence of the accused and in the place where it was seized. Depending upon the situation, Your Honor, if there is a threat to the life of the police officers because of the condition or environment, they can proceed immediately to their headquarters and immediately also put the markings of the on the seized drugs. And it requires, Your Honor, the presence also of the media, the representative from the DOJ, and the barangay official. And the transmission also of the drugs, Your Honor, should be, the chain should be continuous, Your Honor, in such a way that once it is turned over to the investigating officer, it must be duly recorded, Your Honor, identified that and recorded it was turned over to such investigating officer. And once the investigating officer finished the investigation, there must also be a record of the turnover to the forensic chemist, and the marking also and acknowledgement of the forensic chemist should be recorded, Your Honor, and until it is turned over to the court for identification by the witness, prosecution witness, the police officer himself who assist or other witnesses that is competent to testify on the drug that was seized, Your Honor, from the accused.
Who among you have read the case of People versus Spouses, SARDA, GR number 239092, June 26, 2019, penned by Justice Gesmundo? One who answers the question correct, I'll give a bonus grade. Justice Barrios, have you read this case?
Sorry, Your Honor, I'm not aware of that case.
Yes, Justice Lopez.
Not sure.
This is with regard to pre-approved credit cards. Yes, Justice PEREZ.
I'm sorry, Your Honor.
Yes, Justice YBAñez.
That also read that, Your Honor.
So no bonus grades from all of you. All right, thank you, gentlemen, and good luck.
Thank you very much, Judge Ilaw. I'll direct my first question to Justice Lopez.
Yes, Your Honor.
You teach criminal law
Yes, Your Honor.
and you are a former prosecutor.
Yes, sir.
What is the general rule regarding the allegation of aggravating circumstance in the information?
Well, there was a change in criminal procedure. I think it was adopted in the 2000 criminal procedure, Your Honor, that aggravating circumstances must be alleged in the information because of the rule on the right to be informed by the accused. So if the same was not alleged in the information and it was proven during the hearing, it will not be considered in favor of the prosecution, Your Honor. So there will be no aggravating circumstances considered at all, Your Honor, even if proven, Your Honor, during the hearing.
Suppose in the information only the aggravating circumstance of treachery was alleged. There was no specification as to how it was committed. What do you say?
There were conflicting decisions, but as far as I can remember, there was a decision by the Supreme Court. Treachery, the word itself is not enough to describe the aggravating circumstances. The circumstance must be specified in the information itself, Your Honor, how treachery was committed, Your Honor, with the use of firearm, or it was a surprise attack, or whatever it was, that will constitute treachery, Your Honor.
Justice Barrios? Suppose the word treachery was not used, but how the accused committed it was described in the information. Is that sufficient?
In a prosecution for murder, for instance, if the information just states treachery, plain and simple, that will not be considered to aggravate the crime to murder. If at all, that will the case, if the killing was proven, the case will just be for homicide.
Question is the other way around. The information did not mention treachery, but describe the acts committed. Can it be considered as an aggravating?
In my opinion, Your Honor, it should be. If the specific acts constituting treachery are themselves included in the information without specifically mentioning treachery, I still believe that it can be considered as an aggravating circumstance, Your Honor.
Justice PEREZ, is plea bargaining a demandable right?
No, Your Honor, because under the rules, it requires the consent of the prosecution as well as approval by the judge.
Justice YBAñEZ, do you agree?
I believe, Your Honor, the party can demand plea bargaining, Your Honor, because it is as provided in the rules, Your Honor. It is a right that, unless waived, Your Honor, the party concerned who is entitled to that provision, Your Honor, can make a demand that plea bargaining should be made.
Justice Barrios, do you agree? With whom do you agree?
It is my opinion, Your Honor, that plea bargaining needs the consent of the public prosecutor and the complainant, as well as the presiding judge, Your Honor.
We will ask the former city prosecutor, Justice Lopez.
As far as I know, Your Honor, I agree with them. Plea bargaining is allowed as long as the
Now,
prosecutor...
the question is it a demandable right?
Is it a demandable right? There was an administrative order issued by the Supreme Court with regard to drugs, Your Honor. Plea bargaining is not demandable in cases of drugs and in certain other cases, Your Honor. But in fact, there were conflicting resolutions by the DOJ and the Supreme Court. There are instances where the Supreme Court allows it even without the consent of the DOJ, as far as I can remember, Your Honor.
To you, it is a demandable right.
It depends, Your Honor, on certain cases, Your Honor. When
What
it
are
involves
those-
drugs,
What are those
it's not a
situations?
demandable right, Your Honor, because in fact, plea bargaining is disallowed in some instances involving drugs. And I think heinous crimes, Your Honor, it's also not allowed when it comes to heinous crimes. It's not a demandable right, Your Honor.
Justice YBAñez.
Yes, Your Honor. Yes, Your Honor.
You were awarded by the Supreme Drug Abuse Council as an outstanding RTC judge. Correct?
Yes, Your Honor.
Okay. Have you read the case of, are you familiar with Section 21 of Republic Act 6125?
Are you referring, Your Honor?
Section 21,
Section
6125, Republic Act. The dangerous drugs law.
Yes, Your Honor, regarding
Anyway,
Section 21.
it was recently amended. What was the amendment?
The amended, as already stated a while ago, Your Honor, that only two mandatory witnesses should be present would be sufficient to consider the seizure to be duly authenticated, Your Honor, by the two present witnesses, a public official and a representative from the Department of Justice, Your Honor. Unlike before, it requires three. The media
It's no longer stringent.
with that amendment, I believe, Your Honor, it's no longer strictly enforced.
Do you remember the amendment that non-compliance is not fatal?
The non-compliance, under the Romy Lim case, Your Honor, the non-compliance appears to be fatal because the prosecutor will not be required to file immediately the information. He is required first to conduct further preliminary investigation. And if the prosecutor, public prosecutor, files the information, the judge is not required to issue a warrant of arrest. And in fact, the judge may refuse and may even dismiss the information, Your Honor, under the Romy Lim doctrine.
PEREZ, if the officers fail to explain the non-compliance with the requirements of Section 21, is it fatal?
In fact, I think, Your Honor, that's one of the amendments because under the former Comprehensive Drugs Act, there was a safe harbor clause that says that even if there is no strict compliance with the chain of custody requirements, as long as it is proven that the integrity of the drugs are preserved, then it is not fatal. However, under the amendment and under, as I recall, the People versus Romy Lim. There is now an express requirement that if there is a deviation or non-compliance, there must be that sworn statement by the police officer, and if there is no such statement, Your Honor, then it becomes fatal. And that has resulted, in fact, in acquittals.
Is that an element of the crime, non-explanation?
No, it is not an element, Your Honor, but the fact is that
Agree with the dismissal of such cases? Here to explain.
Failure to explain, Your Honor, by the police officer or the arrest seizing officer in accordance with the rules implementing Section 21 puts in doubt the integrity of the drugs. And we know very well that the drugs themselves are the corpus delicti of this offense. And therefore, if there is any doubt that the drugs being presented in evidence are actually the drugs seized during the buy-bust, then there is now ground to rule in favor of the accused.
Let us hear the former city prosecutor, Justice Lopez.
Well, I agree.
Regarding the non-explanation, should it be considered as fatal?
It's not element of the crime, but the corpus delicti is, Your Honor. And the non-compliance with the rules set under Section 21 would go to the very existence of the corpus delicti. It would raise some doubts as to the integrity of the drugs confiscated, Your Honor.
Just because the officers failed to explain, there is failure to prove corpus delicti.
It might affect the integrity of the evidence, Your Honor, but of course, there might have to be some explanation why it was not done, Your Honor.
So under the facts given, there was no explanation.
So if there was no explanation as ruled by the Supreme Court, it should be strictly applied, and so it would go to the very existence or the integrity of the drugs, Your Honor. So I would suppose.
Being the former city prosecutor, what is the remedy of a prosecutor in the trial prosecutor?
If is to call in for the police officer to testify in court, to be able to explain in open court. I think it's still allowed under the rule, Your Honor.
So if the officer is allowed to testify and explain the non-compliance, a judge should not first dismiss the case.
Yes, Your Honor.
Justice Barrios, what is your view?
Yes, Your Honor. It is my view that Section 21 that requires the insulating presence of the witnesses to the photographing inventory is a mandatory requirement. So much so that it is required that after every apprehension or search warrant involving drugs, the presence of first an elected public official and a choice of either a DOJ representative or a media personality must be present during the photographing and inventory of the drugs.
Just limit your
And it must be-
opinion to the non-explanation.
None. Now, if this is so, the apprehending officers must, in their sworn statement to arrest, justify why there was no strict compliance with this mandatory requirement. This is the essence of the People versus Romy Lim case. It must be explained outrightly in the sworn statements of the apprehending officers. Without this, there is no corpus delicti.
So you believe there is no written explanation, the case should be dismissed? Do you not agree with Justice Lopez that the prosecutor should be allowed to explain
No,
to
Your
the
Honor.
presentation of a witness?
No, Your Honor. It is mandatory, Your Honor.
It's mandatory.
If that happens, if there is no explanation, the prosecutor must dismiss the case.
You visit the clarificatory issuance of the Supreme Court on that. Anyway, Justice YBAñez, you were formerly with the OSG.
Yes, Your Honor.
What is the mirror doctrine?
The mirror doctrine, Your Honor. As far as I could recall, Your Honor, this mirror doctrine is
Not encountered it.
if the mirror doctrine, Your Honor, I could recall it right, is if the law is not clear, Your Honor. If the law is not clear and what do you call this?
Under land registration cases.
Sorry, Your Honor, in your moment, Your Honor, trying hard to recall it.
Justice Barrios.
Mirror doctrine, Your Honor, I'm sorry, I cannot recall of any doctrine known as that.
Lopez. PEREZ.
I am certain, Your Honor, it's a principle in land titles and
Yes.
deeds, in land registration, and as best as I can remember, it refers to the doctrine that says that the copies of the title should be a perfect mirror of the ones being kept by the Register of Deeds.
Anyway, it was recent. Actually, it's an old doctrine of inland registration cases, but I think the term there was relax. Yung mirador su casa, you remember that? Oh. What was that, Justice PEREZ?
Your Honor, the doctrine that invokes Mirador de su casa is the doctrine that says that a person may rely on what the title contains. He does not have to be, as the case says, he does not have to be every minute of the day looking out for his interest because the title protects him.
Earlier, Justice YBAñez, you were asked to define transgender.
Yes, Your Honor.
Earlier. What is a transvestite?
Transgender, Your Honor, is
A transvestite.
Again, Your Honor.
Transvestite.
Transverse, right?
You have
Your
no
Honor.
idea.
No idea, Your
Okay
Honor.
lang, we'll just ask Justice Barrios.
I believe, Your Honor, a transvestite is a person that has two sexual organs at the time of his or her birth.
Justice Lopez, what is a transensual? Sexual.
I think transvestite is one who cross-dresses, transsexual who
Yes,
who
that's
changes his
correct.
sex.
How about
Transsexual, the one who changes her sex.
not
Under-
transgender?
Huh?
Transsexual refers to the... I will ask Justice PEREZ first.
My vague understanding, Your Honor, is transgender gender is one who chooses a different gender than the one he or she was born with. Transsexual is one who undergoes transformation from one sex to another. Transvestite is one who publicly acts like according to his or her chosen gender.
If ever you reach the Supreme Court, there will be many cases of international law, public and private. I'll ask first Justice Perez. What is apostille?
Apostille, Your Honor, refers to a treaty that in connection with the authentication of public documents. The former practice is for a public document to be authenticated in a foreign consulate by a red ribbon. But I think under that new practice, an apostille, which is really some kind of authentication without requirement of a red ribbon, is sufficient to accept the document as authentic.
Justice Lopez, is the Philippines a signatory to the Apostille Convention?
I think so, because I have seen it being practiced in the Philippines, Your Honor. Yeah.
Okay, Justice Barrios. Has it been ratified by the Senate?
I do not believe, Your Honor, that this practice requires the ratification of the Senate under our Constitution.
So it is not required?
It has not been, because it is not
because
required.
It will affect our laws on evidence.
It is an international agreement that does not need the ratification of the Senate.
When are non-signatories be bound by a treaty?
If the treaties pertain to general principles of international law, there is no need for a ratification because it is automatically incorporated as part of the law of the land. And, Your Honor, that is under the Constitution.
There are 3 instances. Justice Lopez.
Three instances. I can venture a guess, Your Honor. Well, if it's one, I think if it's part of the incorporation principle in the Constitution, that generally accepted principles of international law are considered part of the law of the land. So if there is widespread...
We are not signatory, even if the Philippines is not a signatory.
If it's considered as a widespread practice in international law, it might be considered as part of the law of the land, Your Honor, even without having signed, or without even the concurrence of the Senate, Your Honor.
Justice Perez.
I'm sorry, Your Honor. I'd rather research this than make a wild guess.
Justice YBAñez.
I would agree, Your Honor, with Justice Lopez that if it is part of international law and general principles which is practiced by different countries, Your Honor, by principle of incorporation or doctrine of incorporation, it can be considered as part of the law of the land and need not a ratification by the Senate. However, if it is, it can be done also by what we call the principle of transformation, wherein if it is a good practice, Your Honor, to settle matters and rights of people, Your Honor, by the transformation doctrine, Your Honor, the practice is that it should be passed to the legislature, Your Honor, to pass law and to make it an actionable or enforceable right, since it becomes a domestic or municipal law.
You decided the case or the petition questioning the legality of PCGG, right?
Yes, Your
In
Honor.
the Court of Appeals. Oh, what is the nature of the coconut levy funds?
The nature of the coconut levy fund, Your Honor, I believe it was declared to be it was declared, Your Honor, to be a government fund, considering that it was an ill-gotten wealth, Your Honor. Because of that, Your Honor, the state can use the fund for the benefit of the farmers who were, the purpose of the coconut fund, Your Honor, supposed to be to finance for the benefit of the farmers, coconut farmers, Your Honor.
Justice Barrios,
Yes, Your Honor.
what is the nature of the coconut levy funds?
Understand, Your Honor, that for every coconut product that is produced, the government takes a certain share. That's the levy. A small percentage to be part of the so-called coconut levy fund, and that is to be used for the development of the coconut industry.
Does it belong to the farmers?
It does, Your Honor. It should be used for the benefit of coconut farmers and the coconut industry at large.
Justice Lopez?
What I know is only from the newspaper account, Your Honor. The law creating the Coco Levy Fund is intended to benefit the farmers and the coconut industry. But based on the Supreme Court decision, it is not a trust fund on behalf of the farmers, but it belongs to the national government through the Treasury, Your Honor.
So if it belongs to the government, it is not considered illegally obtained funds?
I suppose so. Even if it's illegally obtained, Your Honor, it redounds to the benefit of the country, since it will be considered as part of the Treasury, Your Honor.
Justice Perez? You're from Coconut Land, San Pablo?
Yes, Your Honor. The coconut levy funds are public funds. My understanding, Your Honor, context is the question becomes: do these funds belong to the farmers from whose pockets they were taken, or do they belong to the oil companies who collected them? And I think the ruling, Your Honor, of the Supreme Court is neither. They are public funds, and therefore their disposition and disbursement will be decided by the government. And that is why I think Justice Lopez mentions that there is a proposal to constitute these funds as a trust fund for the farmers. The farmers, of course, demand that it be distributed to them because it was taken from them. But that is not the ruling of the court, Your Honor.
What was the ruling of the court?
My understanding, Your Honor, is these are public funds, therefore they are in the
To
nature.
use it for any purpose?
No, Your Honor. They are for a limited purpose because they are in the nature of a public imposition or exactment. But since they were taken from the coconut farmers, then the funds are limited to be used, the use of these funds are limited for the benefit of the coconut farmers.
Well, that will be all. Thank you very much. Your excuse.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you very much.
Thank you very much, and Godspeed, Honorable Associate Justice of the Court of Appeals. So we shall now have a lunch break. The public interview will the public interview will resume at 2 o'clock, Your Honors. We shall have three candidates on deck from the Sandigan Bayan po. Thank you po.